Well, we're back. Another YouTube channel podcast for Marcellino and Tyson. My name is Matt Marcellino. This is Jennifer Moore. She and I are partners here at the law firm. And we like to talk every once in a while about legal stuff. Maybe you have questions about. And today we're going to be talking about
mediation. What is it? What does it mean?
And is it helpful?
Is it helpful? Yeah. Debatable. No.
Depends on the day, right?
Yeah, that's true. Depends on the clients.
What is mediation? What do you think it is?
So mediation is where you and your attorney meet with the other side and their attorney with the help of a mediator and come sit down and try to work through everything. Generally, you're in separate rooms because, like we know, going through divorce is super difficult and tense and emotional, and you can't really get everything done in the same room. So if you're my client, you and I are sitting in our conference room, and then the other party and their attorney are in the other conference room, and then we have a mediator who's one of us, generally a family lawyer, who's bouncing back and forth between us, trying to help us work through everything and come to an agreement on outstanding issues.
Right. So what we're talking about is mediation being used in the family law context.
Correct, yes.
Mediation is used in many other areas of law, right? Mm-hmm. Like maybe next time we bring Clay in here and he can talk about construction litigation.
Right. Very different mediation.
Very different.
Yes.
But so the mediator is typically, like you said, a local attorney.
Yeah.
Somebody that we might practice with, might not. But it's an individual party, typically unbiased, right?
Yeah, neutral.
And the neutral.
Yeah.
And they're supposed to help kind of push both sides to get a little bit more uncomfortable
right.
than they've already been.
Yep.
To try to make some headway on possible settlement.
Yes.
Right?
And I think the important piece of this is that it is attorney-led mediation. It's not both parties individually go into a mediator without the guidance of their lawyers. Mm-hmm. That happens sometimes. I don't think it's advisable. I think you always want to have your lawyer with you and helping you through it, and because it's a really long, difficult day, and there are obviously very complex issues that we're dealing with. So.
Oh yeah, they can go till midnight.
Right.
It just depends upon how much progress you're making or not.
And the ability of the clients to withstand such a long day. Yep. I usually tell my clients that by 2 p.m., they hate everybody. They're going to tell me that they're being walked all over, but I guarantee that the other side is saying the exact same thing. And it's because of what you just said that it's making everybody, the mediator's job is to get everybody to compromise and make you feel even more uncomfortable than you've already felt, with the understanding that that's better than the risk of walking into a courtroom and a judge deciding what is right for you. In the mediation room, you're making the decisions.
Correct, yeah. And you can literally mediate over any of the family law matters: equitable distribution, alimony, child custody, child support.
Right.
Sometimes people try to get all those done in one day. That's, in my opinion,
a lofty goal.
Yeah, it's pretty tough. You should have made a lot of progress going into mediation if you think that's going to be successful.
Yeah.
If you walk into mediation, you haven't had any pre-mediation discussions on how to settle, that's going to be a hard one, right?
Right.
You're probably going to accomplish 1 out of the 4 or 5 that's available.
Yeah. Or start accomplishing everything and then have to set a second day.
Yeah.
And that is a good kind of segue into what you do to prepare for mediation. I always meet with my clients certainly ahead of time to review our preparations, and then prior to that, I'm gathering financial documents. We're doing exchanges of financial documents. Maybe I've gathered them through the discovery process. I'm analyzing everything. I'm analyzing what the estate looks like, what the split should be, what the financial needs are, what the support needs are, what's in the best interest of the children, thinking through varying settlement offers and where my client's willing to go, where he or she should be willing to go or not. And then coming up with that plan and a pre-mediation meeting with my client.
Mm-hmm. Yep. The when you're at mediation or even before mediation, I always get this question from clients and like, well, what if they use it against me in court? Right? Like what if I offered, fine, I'm willing to do every other weekend, like custody schedule, and we don't settle. Can they ask me that at court? Like, well, sir, you already said you would do every other weekend. Why is that changed, right?
Right.
And that's a big fear that people have going into mediation. But is that fear warranted?
Nope. And the mediator is going to tell you that when, like, the second you sit down, that no offers are used in a courtroom. Settlement discussions are not admissible in a courtroom. Mm-hmm. So it's a safe space where you can really try to resolve it and come in good faith and not worry that it's going to come out in a courtroom.
Right. Otherwise, people would have no desire to even make a singular offer,
Right.
let alone
Yeah.
multiple counter offers back and forth.
Yes.
Right?
Yeah. And you really want to be super prepared and willing to budge. Like you need to think about your priorities. The client needs to think about their priorities, what they want, what they're willing to move off of, what they know the other side might want. That's a lot of the analysis that goes into that.
Yeah. Yeah, because sometimes even though the practice areas are what would be called causes of action, right? So equitable distribution is its own cause of action. Child custody is its own cause of action. But can you use the two of them together to try to get an overall settlement? Of course.
Yeah.
There's give and take within each of these causes of action where you might be able to get either some concessions because something might be more important to someone over here rather than in this position, right? So there might be a piece about custody that's very important to you and you're willing to concede on certain assets or take on some more debts or whatever it might be.
Yeah.
You just kind of play off that. So you're constantly moving those pieces around. So we take our laptops to every mediation, right? And maybe sometimes a multiple screen, right? And we're constantly messing. And I think 8 out of 10 times my client is like, what are you reading, ESPN over there? And I'm like, no, I'm
working. Yeah.
I'm going through various different spreadsheets. I'm moving things around. I'm looking at previous court orders and so forth to trying to anticipate what's about to walk in the door, the next offer or counter offer, and then where we're going to go from there.
Right.
So it's a process.
It is. And I didn't mean to interrupt.
No, that's good.
Well, I was going to say, and when does it take place? I think that's another question we get a lot. And not to get too far afield, but you can mediate before litigation is filed. You can mediate, you have to mediate, you're required to mediate once litigation is filed for certain claims like custody and equitable distribution. So most of the time we go to mediation within the context of a lawsuit. But I mean, I've resolved cases in mediation right before trial before. So yeah.
Yeah, I'm a big fan of pre-suit mediation if you can get ahead of it. It does require some cooperation between the two sides.
Yeah.
So, in a later, we keep calling this a podcast. In the next podcast or a later podcast, we're going to talk about discovery, right?
Yeah.
But just quick spoiler, you can't issue discovery without a lawsuit, right? So if you don't have a lawsuit and you're doing pre-suit mediation, how do you get documentation from the other side? There has to be an understanding, you have to work together, right?
And trust.
Correct.
That you're both there in good faith and working together. So
and more often than not, I think it's beneficial. Like I said, I'm a big fan of it. If you can avoid the stress of litigation and the constant time, you can hear that bell just ringing. When's the next hearing? When's the next hearing? And so if you can kind of avoid that, it's good. Plus, saves you a load of money, right? Lawyers are not always cheap. And sometimes litigation is costly, so if you can do pre-suit mediation, great. But otherwise, if you do have to file a lawsuit, more often than not, it's going to be required, and you're going to have to do it again.
Right.
And sometimes you have to do it twice. Sometimes you do pre-suit mediation, fails, that's okay. A lawsuit's filed.
You go to a hearing or two.
Yeah. And
you realize
the court
that
sends
was
you
terrible.
Back.
Yeah.
Yeah. The court sends you back to mediation. You got to do it all over again.
Yep.
It's probably a year later.
Right.
Hopefully by then you've made some advancement in some of your discussions or your settlements.
Sometimes I find that if at pre-suit mediation, people are less willing to budge, but then once they've been in litigation for a while, they're weary, they've been in the courtroom, they've gotten that kind of itch out, and they realize that it's not worth it, and they're more willing to budge and be more, I don't know, maybe reasonable isn't the word, but at least compromise more.
I think the compromise is key, right? I think the old adage is everybody loses in mediation because there's just everyone's making concessions. You're not getting what you want, but you're getting hopefully somewhere close to it, right? And that's the same for the other side.
Yeah.
Whereas if you go to court, every mediator tells you this in their opening spiel, right? Because they go through the rules, and then they tell you, look, if you go to court, somebody in a black robe is going to tell you what to do. You literally have no input. So mediation, you can kind of control your destiny a little bit. And the other side, if they recognize that as well, you can get something maybe better than what you might go and get from a judge.
Yes.
That's very true.
Yep,
right?
it is.
And it's no fault of the judges. It's just facts are presented, they make a decision, and everyone had their opportunity to settle before then.
Right.
Right. So but once you get into that mediation room, the sooner you can recognize, okay, this is beneficial to be here, and you get beyond the I want, and what I want is all I'm going to take.
Right.
Then you start to cook with gas at that point, right?
Yep.
So,
agreed.
Yeah.
Yeah. So overall, mediation is a good thing. Most of the time, our cases are in mediation at least once.
Oh, yeah.
So talk with your lawyer about when and how and with whom. And yeah.
Yeah, mediation is a good thing. So
Mediation.
try to use it.
Yes.
Right on.
All right.